Okay, I'm glad to take part in the third conference after participating in the first two conferences. Some people here reminded me that in the last conference I caused quite a stir when I spoke about greediness and class actions. But in spite of that fact, I was invited to speak again. So I'm really glad to be here. I'll make some short remarks about the Israeli system and a few words about the role of Israeli judges in our system. Now, Israel adopted a law about a law on class actions in 2006. Now, I'll give you some statistics because I think it's very, very interesting. In the year immediately after the adoption of the law, a few dozens of cases were filed. Then the numbers started to climb. In 2010, the number 440 cases were filed. 2013, it rose to 1,015 cases. 2016, 1,556 cases. And then in 2018, the number dropped to 1,260. I believe we have a world record in terms of number of class actions per capita. We also have another world record that's about the number of lawyers. There are some people here from Brazil. We surpassed even Brazil. Now there is one lawyer to every 120 Israelis. Then Brazil, and then I think the United States. Well, we shouldn't be proud about the number of lawyers and neither about the number of class actions. Now, it's interesting because, as I said, last year, in 2018, the number dropped from 1,556 in 2016 to 1,260. And if you ask why, last May, court fees were instituted. And it's unbelievable what happened. In the day before the introduction of court fees, and the court fees are quite reasonable in my opinion, 106 cases were filed in one day. In one day. One day. And since then, the numbers dropped, and as I said, 1,260 last year. It's also a good example how economic incentives change the behavior of people, including lawyers. Okay. Before I'll say a few words about our system, I'll give you some other figures. There are some judges in Israel who have to handle on their docket 150 to 200 class actions. In my opinion, it's simply unbelievable. We heard figures from Brazil, yes, but the figures in Brazil that we saw, they figures about not only class actions, all actions. And I can tell you that to handle 150 to 200 cases, it's simply beyond belief. And the problem is, since there are so many cases, that the judges have to, what do you say, they don't have enough time to separate the chaff from the, the unmeritorious cases from the meritorious cases. That is the biggest problem. I know that I'm sure there are people here, Israelis, who represent plaintiffs, and they complained about the introduction of court fees. But you have to understand that the big problem is, as I said, to separate the good cases from the bad cases. And since there are too many unmeritorious cases, the judges simply don't have enough time to devote to the good cases. Now, what happens in Israel, that a good percentage of the cases, a very high percentage actually, don't reach the end of the line. They are either settled or there's what we call a withdrawal. Many of the cases are withdrawn before certification. When there's a withdrawal, no res judicata, so there's no problem for somebody else, another member of the class, to bring the same action again. Now here again, the judges have a problem. It has to do with fees when there is a withdrawal of a case. Why? On the one hand, the judge who has 100, 150 cases wants to get rid of the unmeritorious cases. And in order to give an incentive, some modest fee in case of withdrawal. But if you think long term, it's no good. It's good because you don't want to give incentives to unmeritorious cases. And that's what happens, unfortunately, if you award even modest fees when there's a withdrawal. Now I'll say a few words about what happens in our system with respect to settlements. Most settlements, most cases that are settled before certification. Because after certification, there are some lawyers here from Israel, that they'll correct me if I'm wrong, very few cases go all the way. And once a case is certified, though in theory, it's not conclusive. Actually, the standard is reasonable likelihood of success in the next stage. But once a judge decides to certify a case, it's the end of the day. That's it. There were statistics done in 2013 that showed that one case out of more than 1,000 cases went all the way, and the case was, the class action was denied. One case out of more than 1,000. So as I said, once a case is certified, it's basically the end of the day, and therefore many of the cases are settled before certification. Now, we have something unique about settlements in order to overcome the problem of the agency problem. When a case, when the court gets a settlement, one of the things that the judge has to do, to refer the case to the Attorney General, of the state. Now you have to understand, in Israel, the Attorney General is a completely independent body, non-political, and that's how the legislature decided to to deal with the agency problem. So the court gets an independent opinion from the Attorney General before approving a settlement. And I think, I'm not saying that every country should adopt the same kind of system, but I think that a system of independent review before approval by the court, it's an excellent idea. What else we have, we heard from the Brazilian professor about the registry. We also have a registry, since we are not a federal state, so it's very simple. When a case is filed, a class action is filed, you have to register it, and then after certification and so forth. So that's also, I think, a very good idea to have a registry. We also have a unique system, and maybe I wouldn't go into it, but a special system with respect to class actions against the government and governmental bodies. It's very different rules. For example, the period, the limitation period is only 2 years instead of 7 years. There are problems with respect to that. There was even a constitutional challenge to the provisions of the law that dealt with class actions against governmental bodies, and the Supreme Court denied the petition. They denied the constitutional challenge. Okay, I think I'll stop here, and I'll ask my colleagues, distinguished colleagues, to say, to deliver their presentations. First, we'll start with Justice Jeroen Corres. Justice Corres is a sometime Vice President of the Amsterdam Court of Appeal, a sometime Professor of Roman Law and Legal History at Leiden University. Now he's an independent senior legal advisor. He graduated from University of Leiden. He got a first degree and then a doctorate from that university. He worked at Edinburgh University, at University College London, University of Amsterdam, and Leiden University. He was appointed to the bench in 1977, first to the District Court and then to the Amsterdam Court of Appeal. Please, Justice Corres, please.
Does it work? Thank you.
Much better.
Well, thank you very much. It's a nice audience. I will skip the Roman law and I will skip the legal history and turn straight away to my practice in the Amsterdam Court of Appeal concerning one particular remedy, one special remedy of collective actions, that is the settlements action. We have in the Netherlands, as from July 2005, we have a special collective settlements act. It introduced this special remedy facilitating collective redress for mass damages of whatsoever kind or cause. This remedy has been petitioned for and been granted so far only in 9 cases. 6 of these settlements concern securities or other financial products and services. I have presided over some of these cases, and most of them display international aspects, some very important international aspect, due to my court's generous interpretation of its international jurisdiction. 4 settlements dealt with damages of shareholders from many countries worldwide, except the United States. Sensationalist commentators wrote that Amsterdam had become the settlement hub for claims involving non-US class members in securities cases. I will not deny that, but I would say with 6 cases only in that field, it seems a bit overstated. I will not go into the international aspects now, how interesting they may be. As I said, the remedy is a settlement-only class action. It's only available if a settlement has been reached beforehand out of court between, on the one side, one or more claim organizations representing the interest of persons to whom damage was caused by a specific event, whatsoever event. I call these persons henceforth victims. And on the other side, one or more parties binding themselves to pay for this damage. Note that no victim is allowed to be a party to the settlement. Victims' interests should be looked after by claim organizations. These organizations may be established consumer or shareholder associations, but they may equally be special purpose vehicles created for this particular case. The parties to the settlement must lodge a petition with the Amsterdam Court of Appeal. It has exclusive jurisdiction in first and final instance, subject to appeal for cassation to the Supreme Court, though only if the request was rejected. So far, no request has been requested in the end. The petitioners request a declaration of the court that a settlement be binding on all victims in order to reach finality. That is obviously an important issue. If the court finds there is no reason for denial, note the negative formulation, if there is no reason for denial, it will grant the requested declaration. Any victim thus bound may from then onwards claim only under the settlement for the compensation allotted to the appropriate category he falls in. It may well be, however, that the settlement doesn't fully or even not at all entitle him to compensation. The victim may avail himself of the opt-out facility, open during a period determined by the court on granting the declaration, for instance, a period of 6 months. An opt-outer may not claim under the settlement. He may start any individual action competent to him previously, but no claim under the settlement. That's logic. In 2017-2018, the Young Remedy passed through a dramatic episode when the court had to judge whether the so-called Ageas Fortis settlement could be declared binding. Fortis was a Dutch-Belgian system bank and insurer, and Ageas is its mother. The price of shares in Fortis was inflated by misleading information during periods from September 2007 until October 2008, causing thereby mass damage to shareholders. After many years of various types of litigation, Ageas concluded an out-of-court settlement with 4 claim organizations. Ageas made over €1 billion available for shareholders and an additional €45 million for the claim organizations. In a first interlocutory decision, the court made it clear it would deny the binding declaration. Why? Under the settlement, to a victim that had joined one of the claim organizations before 2015, a substantially higher amount was to be awarded than to a victim that had not so or not at all joined a claim organization. That was the main objection of the court. Secondly, the court complained it had insufficiently been informed on costs made by each claim organization and by their members. Costs made either in relation to the conduct reproached to Fortis Bank or in relation to earlier litigation, to the settlement or to the class action. The petitioners then offered a corrected settlement and reluctantly gave additional information on their financing models and costs made by themselves and by their members. In its new version, the settlement still distinguishes between victims that did and that did not adhere to a claim organization before 2015, but to a much lesser extent. After a further correction of the settlement, I'm not go into that further correction, in the end the court considered the remaining difference sufficiently explained and justified. The court took in account, as to the money awarded to the claim organizations themselves, the public interest that collective actions are brought before the court, which requires, obviously, adequate remuneration. Generally, that must imply a commercial reward for assuming the considerable risk that funding will not be compensated at all. Though the court was still not satisfied on all counts, it declared the last version of the settlement binding all the same. I think it is no longer disputed that courts must play an active role when dealing with collective redress for mass damages. All the more so for the Amsterdam Court of Appeal when it has to manage the settlement-only remedy discussed here. The victims to be bound once the settlement has been declared binding on them they didn't participate in negotiating and concluding that settlement. In their place, organizations representing victims' interests are parties to the settlement. So there is a gap between the victims to be bound and the settlement. This gap must be bridged to some extent. Victims are summoned to take part in the petition proceedings, and in this way are offered an opportunity to be heard by the court. Likewise, organizations representing the interests of victims but not participating in concluding the settlement, so other claim organizations, not party to the settlement, they are offered too the same opportunity to be heard by the court. But obviously, a huge number of victims will never utilize this opportunity. The court can't take account of their comments and possible objections. The unbridged gap between the victims to be bound and the settlement strongly suggests the active role of the court to be played. Now, the Dutch Civil Code and Code of Civil Procedure contain a number of conditions, negative conditions, which, if fulfilled, must lead the court to a denial of the binding declaration. In view of my theme, bridging the gap between victims and the settlement, three conditions are most relevant. They will sound familiar to you. Condition one, the amount of the compensation awarded is not reasonable, having regard to the extent of the damage, the ease and speed with which the compensation can be obtained, and the possible causes of the damage. Condition two, the interests of victims are otherwise not adequately safeguarded. Condition three, the claim organizations are not sufficiently representative with regard to the interests of all victims, members of this organization or not members. The latter two conditions are clearly of a formal nature. Do the members of the claim organization as a whole not reflect and represent the various types of natural persons and juristic persons qualifying as victims? The court, however, has held that these conditions are not only of a formal nature, but also a material nature. That is, did the claim organization not look after the interests of all victims, particularly the interests of those who are not members of these claim organizations? Obviously, this is the problem which I am addressing, which is called the problem of the free riders. The court has repeatedly stressed that it is not decisive that the claim organizations, parties to the settlements, are regarding the settlement as reasonable and adequate. Not even is it decisive that claim organizations who are not parties to the settlement and individual victims who initially, maybe in the procedure, formally opposed the petition, in a later phase drop their opposition and now adhere to the opinion that the settlement, after all, is reasonable and adequate. Perhaps their consent was bought by an accommodation of the settlement in their favor or by a separate agreement with the party binding itself to pay the damage. In such a situation, the court must still, on its own motion, form its autonomous judgment, among other things, on the reasonableness of the amount of the compensation awarded, also with regard to these free riders who have not been heard. The situation presented itself dramatically in the Agios Fortis case, which I discussed. It had been done so in another case 3 years before. When an ordinary settlement, binding only on the parties who agree to it, has to be judged, the court will, of course, normally regard the determination of its content entirely as a matter belonging to the parties. It is different, however, in the case of a settlement which is meant to be binding on a class of natural persons and juristic persons other than the parties to the settlement. Here, the court must fulfill this most active role just described. The justification lies, as the court has held, mainly in this circumstance that, in principle, the settlement will also bind those victims who were not involved in negotiating the settlement and who could not affect its content. The court must safeguard access to justice to all class members. Additional justification for such active judicial conduct is herein found, as the court has also held, that it is in the interest of the petitioners that the number of victims opting out will be as small as possible. So the gap between victims and settlement can't be removed, but it may be bridged by the courts assuming an active role. Thank you for your patience.
Thank you, Justice Corus. Okay, now we move from Holland to the United States. The next speaker is Judge Robert Dow. Robert Dow has served as United States District Judge for the Northern District of Illinois since December 2007. Prior to joining the bench, he was a partner in a law firm in Chicago. In 2010, Chief Justice Roberts appointed Judge Dow to a 3-year term on the Advisory Committee on the Appellate Rules. Since 2013, he has served, again by appointment of the Chief Justice, on the Advisory Committee on Civil Rules. Judge Dow received his bachelor's degree in History and Political Science from Yale and his law degree from Harvard. Please, Judge Dow.
I hope that's loud enough. Anyhow, thank you so much. It's a great delight to be here. I know as a trial judge in the United States, I spend a lot of time in the provincial world of my own rules and my own cases, and I feel it's a great luxury the last 2 days to get out of my provincial world and see what's going on in the rest of the world. So I thank you all for your education. There's a lot of good food for thought here. We just get so stuck in our own ways and our own systems, so it's a real privilege to be here. My topic today is the role of judges in U.S. class action litigation. And if I had to pick a single word, I would say active. And I know Rick sort of warmed you up for my presentation today by talking about the Rules Committee work that we've been doing. And what we've been struggling to do with the last few years is to have the rules keep up with what's happened in litigation. As Rick mentioned, the class action rule is a little over 50 years old, and I think the framers of the rule had in mind more of a focus on injunctive relief cases, and it's really become much more a significant rule for money damages. and over time the rule has struggled to keep up with the realities of the litigation system. And as Rick mentioned, there are some amendments to the rule that I'll talk about in a little bit that have been online for 4 months now. And so it's a little early to tell whether the rules are having the intended purpose, but I will talk about what we thought we were doing in proposing these rules amendments and how I hope that they're going to end up working. So the role of the district judges. I'm going to talk about 6 particular things that district judges do in the United States in playing this active role in managing class action cases. And I took a quote out of one of the decisions from Judge Posner, who regrettably isn't going to be here, because Judge Posner, to my way of thinking, is one of the giants in class action litigation in the United States for pretty much the history of the rule. I mean, he became a judge when the rule was 15. He left the bench when the rule was 50. And in that time, he wrote some incredibly influential decisions in the area. But this is a quote from one of his cases. And as a judge in Illinois, I lived under Judge Posner's thumb for 10 years. And I can say we all lived in fear of Judge Posner reversing our decisions. So we read them very carefully. But this is what Judge Posner has to say. District judges have a non-delegable fiduciary duty to absent class members to ensure that their interests are protected. And the reason we're concerned about that is that absent class members have an opportunity to opt out if they don't like the direction of the litigation after it's settled. And the reason they have a right to opt out is at the end of the case, if the case goes to judgment, whether it's by settlement or a litigated judgment, they're bound by the outcome. So they're very important actors in the system, yet they're not represented except through the sometimes distant relationship between class counsel and the class members. So there are 6 ways in which district judges in the United States play a role in class action litigation that I could think of, although there are people here who know a lot more about American class actions than I do, so perhaps I've left some out, and I'm sure my friends will point this out to me later. But here are the 6 that I came up with. Appointment of class counsel, class certification, approval of the notice of the class certification that goes along with the opportunity to opt out for absent class members, scrutiny of proposed settlements, objections to proposed class settlements, and approval of attorney's fees. So there are 6 ways in which district judges in the United States play an important role in class litigation. So I'm going to go through each of them just for a few moments here, because I really have about 10 minutes. In terms of appointment of class counsel, so many of our class cases come with counsel already in the saddle, so to speak, and there appear to be no viable alternatives to that class counsel. So in that case, we're really just trying to figure out whether the class counsel can do the job. We're not looking for the best, we're looking for someone who's adequate to the task, and that's the term that's in the rules. And so that's a role that we have to play. Sometimes there are multiple competitors to be class counsel, and that's more common in the MDL type of cases that Professor Marcus mentioned earlier, but a lot of MDL cases have a class action component to them. Could be small, it could be large, but in any event, in both of those cases, class actions and MDLs, the judge has a role to make sure that class counsel is capable, and that's a role that we all take very seriously. But in general, most of the lawyers who've come to me with a class action have been capable of doing what they've set out to do, and so we don't have too many cases where appointment of class counsel becomes controversial. The next stage that district judges become involved in litigation, and actively so, is class certification. So there are fairly detailed rules about class certification in the United States, and our job as the district judge is to exercise our discretion in figuring out whether the case qualifies under those criteria. The common ones that you all hear about, the basic ones under Rule 23A, numerosity, commonality, typicality, and adequacy of representation. Those are basic things that we have to look at as judges and decide whether the case qualifies. And then there are additional criteria primarily for the Rule 23B3 classes, which are the money classes, and those tend to be more controversial and more difficult to apply than the 23A criteria, but predominant, superiority, ascertainability. Those may all be, and I certainly don't have time today to go into what each of those means, but those are other things that the judges have to exercise their discretion in deciding whether to certify a class, because that is a momentous event. And if you want to read an interesting case on that, you can read Judge Posner's decision in Rhone-Poulenc, which actually is not a class certification case. It's actually a mandamus petition. But he raises a lot of the reasons in that case why a class certification is a momentous event. And those are reasons why district judges have to take seriously their job to scrutinize whether a case actually qualifies for class treatment. And as you can imagine, just from the one-word descriptions I've given of all of these criterion, there's a lot of discretion that goes involved in that. And it's not, it's not like litmus paper where it either turns purple or it turns pink. I mean, there's a lot of weighing and balancing that has to go into that decision. And then after the district judge makes the decision, one of the amendments to the rules that's been has come into effect in this century is the, or almost this century, I guess the end of last century, is the ability to take an immediate appeal, and it's discretionary, so you can ask to take the appeal. The Court of Appeals doesn't need to take this, but sometimes the courts of appeals will take the appeal from a district court certification decision and decide whether that was properly done, because it is a momentous thing that happens at that stage. So once the class is certified, what's the next thing that a district judge does to manage a class action case? And in that case, the notice has to be given to the class so that the absent class members can understand what's been certified and what of their rights are at stake in the litigation moving forward. And in terms of notice, there's two things the district judge has to do. One is to figure out what the proper form of the notice is, and for a long time, the rule of thumb has been first-class mail. One of the amendments that was promulgated effective last December was an opportunity that's really judges have been taking advantage of prior to it being placed in the rule, and that is alternative forms of notice that would be best calculated in the circumstances to actually achieve the purpose of letting people know which of their rights are at stake and what the circumstances for opting out if they chose to do so. So that's one thing we have to decide. And I think, you know, some people still use first-class mail. Sometimes the notice goes out and it can be published, or it can go out over the internet. There are lots of innovative ways that people are proposing to the judges in terms of what they think is best suited to give information to their clients in a particular case. But it's the judge's job to approve that. The judge's other job in respect to notice is to approve the actual content of it. What does it say? Is it comprehensible to the audience? And that's another task where the lawyers play a huge role in proposing, and the judge plays a role just in disposing. And sometimes the judge will make a suggestion or a comment. The judge will say, this is too complicated. The parties will fight about the notice. There will be an objection by the defendants. Those are things that the judge has to do to manage the litigation and make sure that the absent class members get an idea of what their rights are and when they have to exercise their opt-out rights if they don't wish to be bound by the rest of the litigation. So the next area that I'm going to talk about is settlements, and I know it's a common feature of American class litigation these days that most cases end in settlement. And that's true of all civil cases. I don't think it's any more true of class actions than it is of other civil cases. So it's possible the case will be dismissed on a motion to dismiss. It's possible there will be summary judgment. It's possible the class will not be certified. But once the class is certified, it's very likely that that case will end in a settlement. And one of the amendments that was also part of the December 2018 package gives the judge a certain criteria to look at in terms of whether to approve a settlement. And it's a very serious undertaking that the judge takes. And one of the other proposals that we actually did end up adopting in the rule is something we've called front-loading. But it's the idea that you're supposed to give the judge information to allow the judge to make a good decision about whether to approve the settlement. And it's also meant to prompt judges to ask the questions that they need to ask to make sure that the settlement is justifiable under the terms. Now, the criteria are very long. I actually did some slides, but I'm not going to. That's what the slide would have looked like if I put it up. And it was incomprehensible to me, and there was no way I could explain this slide in less than the 12 minutes I have. So I bagged the slides all together. But let me tell you, the thing that's most often litigated in this area would be the scope of the relief. Is the relief sufficient in light of the risks and the costs of the litigation? And is the relief fairly distributed amongst the class members? Now, sometimes you have subclasses, and sometimes there are people in your class action who don't deserve the same as other people in your class action. But you have to sort that out and make sure that it's fair to everybody. And then, of course, the other issue that I'll get to in the end here is attorney's fees. That's the other issue that's often fought about at this stage of the case. The idea of the settlements either lopsided to the attorneys, or it's very seldom do the attorneys propose a settlement that's lopsided against them. But that's something that we have to look at as judges in deciding whether to approve a settlement. And I find at this stage we have preliminary approval, which is what we call when you come to the court and ask the notice to come out. At that stage, if people show me what the deal looks like, and I think it looks like something I might have difficulty approving in the end, at that stage I'll call the lawyers in and I'll say, listen, if you want me to approve this in the end, you're probably going to have to do this. And it seems to me pretty commonly the case that when I make a suggestion, the lawyers just do it. Now, I think they understand in the end I can just write it in there, or I can refuse to approve it. But it's an iterative process, and when we see the better information we get at the beginning of the process, before we approve the notice, the more likely it is at the end we're going to be able to approve the settlement. And so the lawyers are very cooperative with the judges in that and very open to the judges' suggestions. What happens if there are people at the stage of class action settlement approval who don't like it? Well, they're called objectors. And our rules amendment actually addresses objectors as well. And if you read Judge Posner's decisions, which I highly recommend that you do if you're really interested in this, Judge Posner's written a number of decisions that have reversed district judges who have approved settlements that he did not think were fair, reasonable, and adequate. And a lot of the impetus for his decisions were objections. So there is a category of good objectors, and those good objectors actually improve the settlements, and sometimes they do so by getting district judges reversed who approved settlements that were not so good. And you can read several of Judge Posner's opinions, and when you finish reading them, you'll understand why we all lived in fear of having a decision of ours reversed by him, because he was fairly direct about his criticism of the district judges. There's also a category of what we've come to understand are bad objectors, and they're objectors who lay low in the district court, they say nothing, and then they file a notice of appeal. And they raise an objection in the appellate court, and then they call the plaintiff's lawyer and say, hey, if you pay me some money, I'll go away, I'll dismiss my appeal. And that's one of the things that we've addressed in the rules amendments that were effective last December, is if you would like a payment for doing good work as an objector, you need to ask the district judge to pay you. Because the district judge is the one who understands that whether you've done good work or whether you're just an extortionist. And that's what we're trying to solve by that rules amendment. The other thing we've done is require that objections be stated with specificity. And that's also meant to smoke out the bad objector who doesn't have a real objection but just wants a payment. If you don't state your rules with specificity, they should be waived. And my hope is that the first time that I say someone has waived their arguments by not stating it with specificity, the Court of Appeals will affirm me on that. We're a little bit early on that, so I don't know yet. The last thing that I wanted to mention, the last major role of a district judge in the United States in the class action system is attorney's fees. So in a class action, whatever fee the lawyer is going to get at the end of the day has to be approved by the judge. And there are lots of ways to measure the value that the attorney has put into the case. Attorneys, of course, in almost every instance have a contract with their clients, and for some people that's sufficient. So the terms of the settlement are the lawyer gets a third, the lawyer gets 25%, the lawyer gets 20%, whatever it is. There are some courts that encourage and some that even require you to do a cross-check of multiplying the attorney's fee against the hourly rate against the hours to see if that's a reasonable attorney's fee. That's not appropriate in every case, and it's not required in every jurisdiction, but it's another way to measure fees. A third thing that I just wanted to point out about attorney's fees is sometimes the lawyers come in and say, the potential for this settlement is $50 million. And then you find out at the end that only $5 million is distributed because you really couldn't find enough people to distribute because it's there's a disconnect between the people who have a right to the money and the people who have actually claimed it. In that circumstances, sometimes the judges will reserve ruling on the attorney's fees until they can find out whether the deal was as good for the class as the lawyers said it could be. So my basic summary is that Rule 23 requires judges in the United States to play a very active role in class action from the beginning to the very end. The judges have to determine whether there's a viable claim to begin with. Then they have to determine if that claim should be certified. And then they have to determine the resolution of the case, which most often is by settlement. And they're complicated cases, but I really do love them. And I love the MDL cases too. Because when you have these complicated cases, you generally get really good lawyers with them. And it's a privilege to be a judge in cases where the lawyers are good on both sides. And I really look forward to them, actually. So I know a lot of people complain about class actions, but as a judge, I really like to manage them because they're really interesting. So thank you all.
Thank you, Judge Dow. Now to the last speaker. Sir Peter Roth is a judge of the Chancery Division of the High Court of England and Wales. Since November 2013, he's the president of the UK Competition Appeal Tribunal. He was called to the bar in 1977, became a QC in 1997, and was a leading practitioner in competition law and public law. He was appointed a judge in 2009. Sir Peter was involved in drafting the new procedural rules of the Competition Appeals Tribunal. He chaired the tribunal which heard the first two applications to bring such proceeding and is currently chairing the tribunal hearing two more. So now we'll hear about the English experience. Please.
Thank you, Justice Grunis. Thank you to the University of Haifa Law School for the invitation to participate in this important conference. It's a pleasure to be back here in Haaretz, and while I know that the Israelis here face your own political excitements over the coming 2 weeks, I can tell you for me it's a relief to escape the political convulsions in the United Kingdom and to enter what I hope is a Brexit-free zone. The great German Jewish poet Heinrich Heine is reputed once to have been asked where he would like to be on Judgment Day. And he replied, in England, because there things happen 50 years after everywhere else. Whether that's true generally, I don't know, but certainly when it comes to class actions, strictly so-called, we are a latecomer compared to North America, not just the United States, but also Canada, the Netherlands, and Israel, where here you've had a class action statute since 2006. So the particular characteristics of, if I get the right one, our class action regime to bear in mind at the outset. First, it's still very new. It was introduced by an amendment to our Competition Act that took effect in October 2015. Secondly, it is only applicable for competition law claims. And thirdly, only for those claims brought in the Competition Appeal Tribunal, the CAT, which I have the honor to preside. And that is a specialist competition court. Unusual in that it's an interdisciplinary court. We have economists and people from the business world sitting on our panels. We sit as a panel of 3 with a judicial chair. And we are a UK court. As most of you, I'm sure, know, the United Kingdom comprises 3 jurisdictions, England and Wales, secondly Scotland, and thirdly Northern Ireland. And it's only at the very pinnacle of the legal architecture in the Supreme Court of the United Kingdom that the three come together. But we, as a first instance tribunal for these cases, are a UK tribunal. The key features then of the UK class action regime in the CAT, first, that bringing such a case, and we call them collective proceedings, needs the approval of the CAT, so we have a certification system unlike the Australians, and that depends on two aspects. First, approval of the suitability of the claims as being combined in a class action, and secondly, to authorize the class representative as an appropriate person to bring the claim representing the class. Secondly, it can be, as I think was originally already referred to, on an opt-in or an opt-out basis. The application for approval will typically state whether the proposed class representative wants it approved as opt-in or opt-out. And for an opt-out class action, the class members must be UK domiciled, but non-UK domiciled persons or businesses can opt in. And thirdly, collective settlements, we've been hearing about, require the approval of the CAT, but again only for an opt-out class action because of this fiduciary duty that the previous two speakers, my colleagues, have referred to. So the role of the judge is relevant for a number of these aspects of the UK system. But before going into the two specific criteria, approval of the case for a class action, authorization of the class representative, there's some other features I should mention which become relevant to that. First, we're permitted to award aggregate damages for the class as a whole. We don't have to calculate individual damages for each member. Secondly, there is full cost shifting, loser pays, and generally the claimant, class representative, will cover the costs risk towards the defendant by taking out after the event insurance. And there's quite a developed market in these ATE insurance policies to cover that. Thirdly, for opt-out class actions, contingency fees are prohibited, and the funder, that's to say if there's a third-party funder, its remuneration comes out of the undistributed damages, that part of the pot of damages that has not been claimed by members of the class. Cannot come in addition. And finally, that if they're subject to that, any undistributed damages will go to a specified charity, that is the Access to Justice Foundation, not back to the defendants. We don't have a general CPRE discretion, as is the case, I think, in the United States and in Canada. We've had, as has already been mentioned, a couple of these cases so far, and there are two shortly to come. The first was Gibson and Pride, which concerned mobility scooters. That's the electric scooters that people who are elderly or disabled physically can have to get about. That was for a class of some 30,000 people. The second was the Merix and MasterCard case, which has been mentioned already. That concerned the MasterCard interchange fee, which had been found by a decision of the European Commission to be a multilateral agreement restrictive of competition. The proposed class there comprised 46 million people. That was everyone who was resident in the United Kingdom over the age of 16 at any time in a period of 16 years between 1996 and 2007. The damages claimed were estimated at up to £14 billion. £1 billion, which I think even by US standards would make it a massive class action. The third is in fact two coming together, arising out of the trucks cartel. I think there are cases in Israel arising out of the trucks cartel. There are cases in many countries in the EU arising out of the trucks cartel. We indeed have quite a number of individual claims arising out of the trucks cartel, some of which for a very large number of claimants. One is for 156 claimants, but that's not a class action. It's a group action. These class actions follow on from the European Commission's decision. Perhaps interesting to note, they are cross-border class actions. The defendants who participate in this cartel are the major European truck manufacturers, Daimler, DAF, Volvo, Iveco, and so on. And finally, two parallel class actions that have recently been filed against two UK train operating companies on behalf of some 2.9 million rail passengers. That is a standalone class action, and the proposed class representative, Mr. Gutman, is, I think, the former head of research at a consumer rights body, someone who'd been very involved in consumer campaigning. I mustn't say too much about, of course, either of the last two, because they are pending before me, and indeed the solicitor for Mr. Gutman is here in the audience, so I must be particularly careful about what I say. So, what are the criteria that the judge must apply for approval? As Judge Dow so pertinently observed, we must be active. In the consultation that preceded our new law, the government in its response said this: there should be a strong process of judicial certification, including a preliminary merits test, an assessment of the adequacy of the representative, and a requirement that a collective action must be the best way of bringing the case. And as the tribunal observed in Merrick's, the tribunal should scrutinize an application for such an order with particular care to ensure that only appropriate cases go forward. So what about these two statutory conditions? Certification of the claims. The requirement in the law is that the claims must raise the same, similar, or related issues of fact or law, what we refer to for convenience as common issues, and be suitable to be brought in collective proceedings. So there is no requirement, unlike Rule 23 of the federal rules, to which a lot of reference has been made, that the common issues must predominate over the individual issues, something that I gather has given rise to quite a lot of argument in US cases. Equally, there is no requirement, as I just heard exists in Israel, that we must find that the claim has reasonable likelihood of success. We will look, particularly in opt-out cases, at the strength of the claim, but it's not such a merit standard as that. Then authorization. The proposed class representative must be authorized on the basis that it is just and reasonable for that person so to act in the proceedings. And we aim to deal with the whole approval process in about 6 to 9 months from the lodging of the application. We don't encourage any extensive disclosure process before taking these decisions. And how has this then worked out? First of all, I should say something about Merrick's and MasterCard, because quite a lot of reference has been made to that, with, I have to say, a certain amount of mischaracterization, bordering on caricature of what happened in that case. The tribunal in the first two cases looked, as we do, at foreign jurisprudence, and in particular at some judgments of the Supreme Court of Canada, and we adopted the test that Justice Rothstein set out in one of the leading Canadian cases, Process and Microsoft. It's there on the slide. The expert methodology must be sufficiently credible or plausible to establish some basis, in fact, for the commonality requirement. This means the methodology must offer a realistic prospect of establishing loss on a class-wide basis so that if the overcharge is eventually established at trial, there is a means by which to demonstrate that it's common to the class. The methodology cannot be purely theoretical or hypothetical, but must be grounded in the facts of the particular case in question. There must be some evidence of the availability of the data on which the methodology is to be applied, which is not, you may think, a particularly high or inappropriate test. It seems to work very well in Canada. It enables quite a lot of class actions to proceed in the Canadian provincial courts, but it's a means of, as it were, weeding out or excluding cases which are not suitable. And in Merrick's, the problem was that the claimant simply was not able to put forward, in our view, a sustainable methodology for estimating the extent of pass-through across all retail sectors of the UK economy over the 16 years of the claim. There were many direct purchaser actions against MasterCard for the overcharge. I think there are something like 50, 60 claims now pending in the English courts. This was, as it were, an indirect purchaser, depending on showing pass-through. It's clear that pass-through is quite possible, but to get the aggregate figure of damages, you have to find some way of calculating pass-through across every retail sector of the economy, because, as mentioned earlier, this was a claim for damage on the basis of every single purchase of goods or services by every adult in the United Kingdom over these 16 years in total. And as the experts called on behalf of the claimant readily acknowledged, the degree of pass-through in, say, the rental car market might be very different from the degree of pass-through among supermarkets selling food and groceries, which might be very different from a boutique fashion store, which might be very different from an online purchase of home insurance, etc., etc. And we had a very distinguished economist, the holder of the chair in economics from Oxford University, on the panel, who questioned the experts, and it became clear that the method they put forward did not meet that process test. Furthermore, they weren't able to show that the data that they required to do this was likely to be available across the board. And that really was the big problem. There was a separate problem, which that there was no reasonable or practical means of distribution of the total award, even if you could get to it, that was put forward, which even on the most approximate, rough and ready, estimated, broad brush, whatever loose term you want to use, could correspond to compensate the members of the class for the loss they suffered. Some would be hugely undercompensated, some would be grossly overcompensated. So it failed the suitability test. The Gibson Pride mobility scooters case was referred to and described very well in the earlier panel by Roger Burnett, and I won't say any more about it. Authorization of the class representative, that was challenged also in the MasterCard case. There it was challenged not because of the character of the individual. Mr. Merrick's was a solicitor. He had been the insurance ombudsman, subsequently the financial services ombudsman. He was of high integrity and competence. The problem was the funding agreement that he had entered into with a third-party funder and whether it met the requirements of the legislation. And MasterCard mounted a full-blown challenge to that. We rejected that challenge, save on one point on which the agreement required amendment, and there was no problem about amending it. So if the claim had been found suitable, then the second criteria in our role as the judge, Mr. Merrick's would have satisfied. And Mrs. Gibson, in the first case also, was found suitable to act as the class representative. And finally, yes, settlements. There are the criteria and the way we have to approach it. It can be either, of course, after the proceedings have started and we've authorized it for a class action, or, as in the Netherlands, we have the facility to approve a settlement before the class action has even started. And a class member can opt out of an approved settlement. And the one thing we've provided for in our rules, which perhaps is of interest, is that if the tribunal refuses to approve the settlement, then a different tribunal will proceed to hear the trial, because we will be shown the lawyer's advice and the lawyer's opinions as part of the approval process, and it's then not appropriate to hear the case. But as you gather from the fact that we've had just these 4 applications and none's gone through, we haven't had any settlements yet to approve, so I have no experience on that to share with you, and when it does come, we will certainly look to learn from the experience of the Netherlands in how, as judges, we should approach collective settlements. Thank you.
I'm not sure. Do we have 5 minutes? Oh, okay. I'm told that we don't have more time. I wanted to ask. 5 minutes. Well, just one question. You see, many of the settlements come before the court before certification. And I wonder, how can the court make sure that it's a reasonable settlement before hearing the case? You know, before even certification. So in the States, we heard there are objectors. As far as I know, in Israel, only in a few cases we had objectors, but the lawyers would correct me if I'm wrong. Therefore, in Israel, as I mentioned before, we have this system of referral to the Attorney General. And when there's no such system, no independent review or opinion, how can you make sure, especially again when the settlement comes before you at an early stage? And again, what about settlement class when there's no case at all? Please.
Sure. We do not, you couldn't have a settlement without the class being certified, because the defendant will not pay until the defendant gets a release. And so that's part of the problem. Sometimes we get what we call prepackaged settlements. So the complaint comes in with a settlement, basically. But it's still the same process. It's just truncated, and the judge knows nothing about the case when it just comes in at the complaint stage. Part of the rules amendment package that we just passed, it would still kick in there, and the judge would have to ask a bunch of questions and make sure that with the prepackaged settlement and the request for approval, all the information the judge needs, that sometimes you get over the course of litigating a case for a year or two. It comes in on day one, but you still have a right and really an obligation under Rule 23 to ask for the information so you can certify the class. And if you don't certify the class, they can't bind everybody. So I think it would work the same, basically, whether it's a prepackaged settlement you get on day one, or it's a settlement that you wring out of everybody after 5 years of litigation. One way or the other, it's going to work out. It should work out the same in terms of what our judges have to do. It's just a very truncated process, and much more reliant on the lawyers, because you haven't seen anything. Sometimes over the course of a year or two of litigation, you can start to see where the possible holes are, the possible problems, or what questions you'd ask. If it all comes in pre-pack on day one, you know, you're scrambling a bit, but you still have to satisfy yourself. And until the judge signs on the dotted line, there isn't anything that's binding on anybody.
Okay, thank you. Okay.
Well, In the Netherlands, there are various ways in which help the court to come to its decision. First of all, the court is not a single court, but it's a panel of 3 justices. That in itself, of course, does not solve the problem. But the court has a much larger competence to question, first of all, the parties who are present there. Now, in most cases which I dealt with, the settlement-only class actions, in most of these there were opponents. So they brought arguments in, and they perhaps brought in expert evidence, but of course partial expert evidence. The petitioners themselves, they too brought in expert evidence, especially on the scheduling of damage. You need economic analysis of what happened, and then anyway, that is a basis. And then there is, and that's, I think, rather important, the court has also a power to, on its own motion, to appoint an expert, a court expert. Yeah. So far, the court has only done that once, and that had to do, well, I'm not going into too many details, but the court has this possibility, and the parties know that. So that really already makes the level of their arguments rise more than in other cases. Normally, the judge would never, on his own motion, decide to ask expert evidence. He wouldn't do that. Only if there would be a reason alleged by the parties. But in these cases, particularly the Code of Civil Procedure empowered the court to appoint experts on its own motion.
Okay. Sir Peter, please. Yeah.
Clearly it's challenging. I'm not sure it's a unique challenge to class actions. If a case is brought for an infant, for a child who suffered personal injuries, and there is a settlement, it only is effective if it's approved by the court. I, as a judge of the Chancery Division, have been presented with an application to approve variation of trusts, including for the benefit of children. And again, it's all presented as everyone's agreed, but I have to form a view that it does truly and fairly protect the interests of children in the beneficiary class. So we do face this in other areas, and while it's nice to think class actions are unique and special, no doubt lawyers in other fields also think they're special. How would we go about it, and how do we expect to go about it? I think we would, as in those cases indeed, be, in the first instance, reliant and take comfort from the UK system of the independent bar, so that as well as the solicitors representing the various parties, they will have independent counsel, and seeing counsel's opinion from either a joint opinion or from both sides, their respective opinions of why they have advised their clients that this is an appropriate settlement, would be quite significant for the court. And the lawyers, the counsel, the barristers who do these cases are generally quite specialised in them. Certainly that in New South Wales, I think they also have a divided profession, and reading judgments from the courts there on settlements, they have relied quite strongly on counsel, and certainly that's what we do with children's cases. And so we see what is otherwise very privileged material, and that's why, as I said earlier, if we should reject the settlement, it's not appropriate as a judge then to continue with the case. That means our time is up.
Your time is up. Thank you. And now we go for a break. Okay, 10 minutes break.